If you don't mind, we'll begin. Thank you, everyone, for attending today. We are very pleased to announce that Mr. Pugachev has successfully registered his claim against the Russian Federation for damages in excess of $10 billion US. This is similar to the claim filed by Yukos and other parties recently against Russia, as the regime has continued to take certain actions to deprive investors of their investments. Mr. Pugachev is not the first. Certainly he's not the last, but hopefully we can get some form of recompense as a result of these efforts. Let me please quickly introduce my associates here to my left. We've assembled a number of members of our legal team. I would say that behind each of the parties in front of you represents a flanks of other attorneys and advisors that will assist in these efforts. So if you could please go to the next slide. Thank you. So just briefly, Lia Forestier is from the firm Bourdon and Forestier. She is assisting with all French criminal matters Mr. Pugachev has initiated in the French Republic, and also to assist on relief from the Interpol Red Notice. Patrick Hunziker is assisting in the Swiss proceedings, which Russia has initiated for information related to certain banking transactions of Mr. Pugachev concerned with the bankruptcy of a bank that they allege Mr. Pugachev allegedly owned and controlled. And in addition, Patrick is assisting with Swiss parallel proceedings that were opened, which will be briefly discussed today. Nick Cherryman of King & Spalding is assisting in the UK efforts, which Russia has commenced through an agency of the central bank called the Russian Depository Agency. Civil claims against Mr. Pugachev related to the bankruptcy of Mezprom Bank. Those proceedings have received a lot of press worldwide, and we anticipate that a claim filed yesterday in those UK proceedings is for the arrest of Mr. Pugachev in relation to those UK proceedings. Ed Kehoe from also King & Spalding to the left. Frankly, he's a very renowned international arbitration practitioner, and he is leading, in fact, the team for this claim against the Russian Federation. Tatiana. Mr. Pugachev, I just want to make a very brief remark about exactly why we are here today and what occurred. The history of Mr. Pugachev as an individual is well documented, and I won't labor you with the details of Mr. Pugachev and his personal life. What I will say is that the investments that Mr. Pugachev owned and were taken all involved at different times permissions and other requirements of the Russian Federation. The involvement, for example, of then Prime Minister Putin, the involvement of President Medvedev in the relieving of certain investments, and you will see that the type of investments were taken were so diverse across so many industries, and to lose that many investments in such a short period of time could only have occurred with the coordination of different instruments of the state. And as a consequence, the only recourse possible, we believe, is through the international treaty that exists between France and Russia for investments related to those two countries. In addition to expropriating Mr. Pugachev's various assets, those assets involved a real estate development at 5 Red Square, in which very prominent business persons were invited to participate, including Sheikh Al-Walid, Prince Sheikh Al-Walid of Saudi Arabia, to assist with that project. Over $1 billion in finance was obtained for that project. The Northern and Baltic shipyards, those are the shipyards that assisted with the Mistral shipbuilding contract of such recent discussion in French media, and of course relevant because of the sanctions against Russia now for their conduct in the Crimea and in the Ukraine. EPC is one of the top coal deposits on Earth, and the quality of the coal is relevant, and that coal is to finance the development not only of Russia but also for China, and is complemented by the largest railway construction in the last 20 years of the Russian Federation. 400 kilometers of railway was to be built, the most since World War II to be undertaken for a single project. Gribanovo and Optic Trade are conveniently located on the river, where basically door to door from the Kremlin to Gribanovo is how you can find your way. Gribanovo is a very relevant project where, if you check the real estate registry, you will see that President Putin's residence is located just on the border of this development, along with other notable parties. In addition to that, other damage was caused by the unfair treatment. That unfair treatment includes groundless and baseless criminal claims against Mr. Pugachev and the civil complaints against Mr. Pugachev related to the bankruptcy of a bank that he divested of in 2003, the issuance of the arrest warrant in Russia, the Interpol red notice, the request to the Swiss authorities, which you will hear later blocked his bank accounts, the attacks in the UK freezing order to basically prevent him from leaving the jurisdiction of the UK while he yet had been convicted of no crime and is a French citizen, which causes the specter of the European Convention of Human Rights to have to be brought into the discussion and to be considered. All of these things are things which, frankly, are inexplicable in our view. I'm going to please allow you to view a very, very short video, I won't take your time, to articulate the vastness of this empire that was stolen effectively in a period of 15 to 18 months. So thank you for your patience with this brief video.
United Industrial Corporation (OPK) is one of Russia's largest diversified corporation, managing more than $13.5 billion worth of assets. OPK is managing shipbuilding assets, including such industry majors as Severnaya Verf, Baltijski Zavod, Iceberg Design Office, and other machine-building facilities. During OPK's operation in this sphere, the shipyards have supplied their customers with military and civil ships costing a total of $3.2 billion. OPK's strategic target is to set up a modern shipbuilding facility capable of making seagoing vessels ranging up to 300,000 tons in deadweight, the annual deadweight output being 500,000 tons. OPK Development is the real estate development line of United Industrial Corporation's business. OPK Development is one of the leaders in the implementation of unique projects in the exclusive real estate, business-class real estate market. Restoration and renovation of a historical complex at 5 Red Square, Moscow has proved to be the ultimate achievement of new Russia's development industry. The complex will house a deluxe hotel, which will have 78.7 thousand square meters of apartments. Being the biggest player on the market of premium housing in the Rublovo-Uspenskaya highway, OPK Development has more than 1,100 hectares of land in an ecologically clean place at the confluence of the Moscow and Istro rivers, just 12 kilometers away from Moscow. At the historical center of St. Petersburg in the Vasilievsky Island, on a site measuring more than 60 hectares, one of the most ambitious development projects of the northwest of Russia is being implemented. It is the construction of new modern neighborhood units with housing, hotels and residential projects measuring more than 2.8 million square meters in total area. Furthermore, a number of projects measuring up to about 250,000 square meters in total area are being implemented at the historical center of Moscow. In the mining industry, OPK is represented by OPK Mining, which is developing the Yeniseiskaya Industrial Company project, Russia's biggest infrastructure project, consisting in construction of a 460-kilometer-long Kyzyl-Kuragina railroad in connection with setting up of a modern coal production facility in the Elagest coal deposit in the Republic of Tuva. It is to produce 15 million tons of marked ZH coal concentrate, which is in short supply in the domestic and foreign markets. Railroad project implementation is supported by the state using the financial resources of the Russian Federation Investment Fund. The state investments into the project amount to 51.7 billion rubles.
Thank you all for your patience. What I'd like to point out is this presentation was not prepared for this press conference. This presentation was presented at Davos, actually, in 2008, while Mr. Pugachev had retained all of his investments. And if you consider the fact that in 2008, this was presented to the world leaders, and yet today, Mr. Pugachev is effectively in fear of his life and safety, in fear for his family, staying in France without the possibility to travel, with his bank accounts frozen. It is really quite remarkable that such a thing could occur in such a short period of time for Mr. Pugachev. With that, I'd like to turn it over to my esteemed colleague, Maître Forestier. Lee, if you could please come up and share with us the wonderful experience Mr. Pugachev has had with the French proceedings here in
Oui, donc nous sommes en charge simplement des volets pénaux en France. Pour M. Pugachev, je reviendrai simplement très rapidement sur l'activité de M. Pugachev ces 20 dernières années en Russie. Donc en plus d'avoir créé une banque qui est devenue une des plus importantes en Russie, Monsieur Pugachev a développé des entités qui ont été regroupées sous le groupe OPK en 2010, avec notamment EPC, qui est une société qui détenait une licence d'exploitation de l'un des premiers gisements de charbon à coke, et dont la valeur de marché était évaluée par des cabinets indépendants à 2,5 milliards de dollars en 2010. Par ailleurs, il y a la holding OPK Chantiers Maritimes qui regroupe 3 chantiers navals et dont la valeur était évaluée en 2010 à 3,3 milliards de dollars. Et il y a aussi un pan qui porte sur le développement de projets immobiliers. On rappellera que M. Pugachev est citoyen français depuis 2009, ce qui justifie notamment la compétence des autorités judiciaires françaises, et qu'il a investi plus de 200 millions d'euros en France en l'espace de quelques années. Vous l'avez vu, le pouvoir, les autorités russes sont habituées à procéder par captation des biens privés par la puissance publique, par le jeu d'agents publics. Toutefois, qu'une personne atteint un certain niveau de pouvoir politique et une puissance financière, et ne montre pas une allégeance au pouvoir en place qui soit absolument parfaite, ces activités deviennent un objet de convoitise. Vous avez en tête différentes affaires, notamment des oligarches non plus connus, mais aussi de petits entrepreneurs qui seront moins connus et qui subissent les mêmes choses. Donc les premières pressions ont commencé pour M. Pugachev dès 2009, où le président Poutine le sommait de ne pas vendre ses intérêts dans ses entreprises à des intérêts financiers, à des intérêts étrangers. Donc très rapidement, ensuite, M. Pugachev a reçu des propositions par des structures russes, avec des propositions d'acquisition pour un prix facialement à la valeur du marché, accordé avec la valeur du marché. Toutefois, les prix n'étaient jamais versés, ce qui a créé des difficultés financières pour chacune des entreprises et qui a mis à mal, qui a déstabilisé la solidité financière du groupe. C'est une tactique pour faire perdre de la valeur et qui permet dans un second temps de procéder par une nouvelle proposition d'acquisition à un prix nécessairement plus bas. Parallèlement, M. Pugachev, comme vous l'a dit mon confrère Michael, a subi des menaces sur son intégrité physique et sur celle de ses 5 enfants. Il a eu des menaces où on lui a dit, bien évidemment, à l'oral, que ses enfants, bien que ses enfants soient à l'étranger, n'étaient pas à l'abri. Il y a eu une multiplication, par ailleurs, de procédures en Russie qui ont donné lieu à un mandat d'arrêt, à 2 mandats d'arrêt internationaux. Je reviendrai dessus un petit peu plus tard. Nous concernant, je laisserai mes confrères développer sur les autres volets de l'affaire. Sur le territoire français, il y a eu une combinaison de menaces à son intégrité physique et celle de sa famille et un processus de perte de valeur sur ses actifs qui l'ont conduit à être contraint d'accepter à vil prix de nouveaux arrangements, une forme de cavalerie qui portait les prix toujours plus bas. Tout ça sous l'égide d'organismes publics comme l'ASV, qui est l'Agence d'État d'assurance des dépôts russes, la Banque centrale de Russie, sans lesquels il est impossible, bien évidemment, d'obtenir des financements sur le territoire russe. Donc on assiste à une véritable asphyxie par l'autorité publique de l'activité économique qui, combinée aux menaces sur sa famille, a conduit M. Pugachev à accepter parfois des arrangements en sa défaveur. Nous avons donc décidé de porter plainte pour escroquerie en mode organisé, dans le cadre notamment de la vente de PC, à l'occasion de laquelle M. Pugachev a été contraint de céder sa société à un investisseur russe malgré une offre sous-évaluée et dont le prix n'a par ailleurs jamais été versé. C'est un volet qui sera bien évidemment revu dans le cadre de la procédure d'arbitrage qui a lieu à Londres. Il y a eu aussi une extorsion de signature en bande organisée, toujours avec cette circonstance aggravante, une tentative d'extorsion de fonds qui portait cette fois-ci sur la remise de 350 millions de dollars contre la protection de sa famille et la protection de ses affaires d'un point de vue général. Donc 2 juges aujourd'hui ont été désignés au sein du pôle financier du TGI de Paris et nous avons bon espoir que la lumière puisse être faite sur les méandres les plus scabreux de cette affaire. S'agissant enfin de la procédure, le recours que nous avons intenté contre Interpol, une première notice rouge avait été émise par Interpol sur le fondement donc, d'un mandat d'arrêt international émis par les autorités russes. Cette notice rouge a été retirée suite à des décisions des tribunaux du district de Basmanie et de Moscou qui se sont prononcés sur l'irrégularité des procédures ayant justifié l'émission de cette première notice rouge. C'est pourtant sur ce même fondement et sur le fondement de ces mêmes procédures que les autorités russes ont demandé une seconde notice rouge dont nous contestons aujourd'hui la régularité. Donc nous avons bien sûr dénoncé ce que nous considérons être une nouvelle tentative d'instrumentalisation de la coopération judiciaire internationale à des fins politiques. Nous rappelons à ce titre que la Russie a ratifié la Convention européenne des droits de l'homme depuis 1998, ce que nous n'avons pas manqué de rappeler à Interpol, dont nous espérons qu'elle fera une application stricte de son règlement à l'aune de ses principes fondateurs. Voilà pour ma part.
Thank you very much, Leah, for your excellent review of the situation regarding the French proceedings. I'd like to mention that the theme, if you were, the 2 themes of this press conference are, number 1, that the Russian state has no problem using what would appear to be normal, legitimate standard mechanisms to somehow extend their reach into jurisdictions that normally they could never reach. They do this by creating false claims in Russia with no convictions and use the goodwill of the international community to establish a good legal framework to extend their reach into these regimes. The French situation is one. Patrick will now present what is happening in Switzerland, which actually was the first blow internationally against Mr. Pugachev. So Patrick, thank you for a brief presentation.
Thank you, Michael. Is this working? Okay. Bonjour, mesdames et messieurs. Good morning, ladies and gentlemen. Well, Michael, you have almost said everything. There's not much for me to add. In Switzerland, we have two proceedings. One is of administrative nature and is called mutual legal assistance proceedings. The other one is a Swiss domestic criminal proceedings that was triggered by the mutual legal assistance proceedings. I start with the first one. Switzerland is bound by treaty to provide mutual legal assistance to foreign countries, including Russia. The Russians know very well how this works. So in 2013, they filed with the Swiss authority a request that is aimed at collecting some documentation concerning some bank accounts in Switzerland that the Russian could identify as the beneficiaries of 3 transactions where the funds came out of Russia. That request was filed by the so-called investigative committee of Russia, which is in charge of serious crime, but who actually happened to investigate all so-called politically oriented crimes or prosecutions. As I said, the Russians know very well how the mutual legal assistance works. So they file a request, very aggressive and quite simple at the same time. It's a 4-page request that simply states that some offenses would have been committed in the context of the bankruptcy of Industrial International Bank, and that some transactions may be linked to those alleged offenses, and thus the Russians are seeking the cooperation of the Swiss and are asking for the Swiss to send over to Russia the documents related to those transactions that took place in December 2008 and April 2009. For those who are a little bit familiar with mutual legal assistance, you will know that the Swiss are not really prepared to deny cooperation to big players, whether Russia, Brazil, or Egypt. There are a lot of foreign affairs consideration in this context as well. So unfortunately, the likely outcome took place in Switzerland in December 2014, and then in September of this year, 2015, in the usual 2-steps procedure where the so-called Swiss executing authority orders the transmission of the documentation, and the court then backs this authority. Our client now must take the decision whether he wants to complete an appeal against this decision, and for the time being, no documents whatsoever have been sent to Russia in this context. I'm turning to the other proceedings, which, as I mentioned, is a Swiss domestic criminal proceeding that was triggered by the request filed by the Russian in 2013. Since the mid-80s or so, the Swiss practice is that upon receipt of a foreign request for mutual legal assistance, well, then the Swiss will open their own domestic proceedings and investigate the case. The mutual legal assistance proceeding is not about guilt, is not about fact findings whatsoever. It's merely about transmission of some documentation to a foreign country where the verdict is to be taken. The Swiss domestic criminal investigation is about fact findings and about guilt. The Swiss, upon opening of their own proceedings, took some conservative measures that the Russian perfectly knew that this will happen in Switzerland, and ordered the freezing of some accounts of our client. Then the Swiss turned to the Russians and asked the Russians, you provide us with the evidence related to the origin of those funds that you are questioning, and with the alleged predicate crime in Russia. It took 8 months to the Russian authority to answer, and typically in the case where we happen to understand that there is actually no evidence for any wrongdoings, the Russians simply sent, I think it was about 250 pages of documents that are of no relevance at all to the Swiss investigation. Those are corporate documents, minutes of hearings, but that are totally unrelated to what is under investigation in Switzerland. So in Switzerland, no charges have been brought against our client. Nothing happened actually, and the Swiss decided to suspend their own investigation pending the outcome of the Russian investigation.
Thank you. From a practical standpoint, just the human element is that as a consequence of opening the parallel proceedings, the Swiss authorities then proceeded to block the accounts of Mr. Pugachev in Switzerland, which contained relevant sums and contained relevant investments. Most importantly, one of those companies actually was financing and responsible for the Hédiard investment here in France. And the blocking of the account, therefore, by the Swiss authorities had a direct impact on the ability of Hédiard to continue on a normal basis. The other investment notable that was affected was a U.S. investment that Mr. Pugachev had been involved with in different capacity for some time. And that investment was related to a very specific blood technology, which has a very relevant value. That company subsequently entered bankruptcy in the United States and is no longer available for Mr. Pugachev to attempt to be involved in. I'd like, for the sake of time, to quickly turn to the UK proceedings, which have, again, received such notoriety recently. But I would mention that the Russian request to the Swiss authorities for information was before there ever was a crime accused of Mr. Pugachev personally. He was not even accused when they asked for that information. He wasn't even the object of the investigation. Later, he became an object of that investigation, and conveniently, in evidence presented before the UK courts, one of the witnesses has confirmed that the agency of the central bank works closely with the Russian Investigative Committee, which is responsible for the prosecution of serious crimes. So the contention that the Russian central bank is independent from the prosecutors, is independent from the politics, simply is contested by Russia's own state evidence presented in the UK proceedings. Nick, if you could please address in relatively short order, I apologize, the UK proceedings, I would appreciate it, and then we can answer more during questions and answers. Thank you, Nick.
Good afternoon. My name is Nick Sherryman. I'm a partner with King & Spalding, and together with my partner Tom Spray, I head up the team in London that deals with the English proceedings.
Watch the antenna. There you go.
In July last year, proceedings were commenced against Mr. Pugachev in London. Those are not themselves substantive proceedings. They are ancillary proceedings based upon the fact that there is already a civil claim against Mr. Pugachev in Russia. So it's important to understand these are not substantive proceedings in their own right. In the English proceedings, something that's peculiar and unique to English law, the claimants are able to get, and did get, something called a freezing order against Mr. Pugachev's assets worldwide. In the context of that order, Mr. Pugachev was obliged to tell the claimants and the court in London about his assets worldwide. The other side also obtained an order against Mr. Pugachev, restraining him from leaving the country whilst the asset investigation is ongoing, and it's still ongoing, and we are now in September 2015. These proceedings have been going on for, 14 months, and they're still proceeding. There is still no attempt by the claimants in London to enforce or have any judgment from Russia recognized against Mr. Pugachev, and if they're ever going to do so, we haven't been told when that's going to be, if that's going to be. As part of the campaign against Mr. Pugachev in London, he has also been the subject of a detail of people following him very closely, and there have been other measures taken in relation to his cars, where devices were found on his cars which caused a considerable alarm and anxiety on the part of Mr. Pugachev and members of his family as to what was really going on here. These are matters which have been reported in the national press, and are still matters which are the subject of investigation by Mr. Pugachev and his advisors, including proceedings which are being commenced in London against those who appear to be responsible for having placed those devices illicitly on Mr. Pugachev's motor cars. So without further ado, I was going to hand over back to Mike.
Great. Thank you, Nick. Thank you for that. I'd like to build a bridge, please, for those of you attending. Quite importantly, the extortion request in France was related to members related to the agency of the Russian Central Bank that we spoke about earlier. And in addition, it's related to a party that was seeking to acquire EPC, and that party, the partner of that group, is related and a known close business associate of President of the Czech Republic, Chechenian Republic, excuse me, Mr. Kadyrov. And as a consequence of the involvement of the various personalities, the Chechenian Republic president, the strong partners of different oligarchs, the state institutions, and then, of course, in the UK, it's been disclosed, and it's relevant today because you may ask, why is Mr. Pugachev not here today? And the reason he is not here today is, I can confirm, as recently as Saturday, when I was with Mr. Pugachev, together in a vehicle, we were followed here in France. We've asked counsel to see what is possible to do about that. Mr. Pugachev was again followed yesterday here in Paris. In the English proceedings, counsel has, for the Russian agency, has confirmed that they engaged a firm named Diligence. Diligence has been hired to survey and follow Mr. Pugachev since at least July of 2014. And a claim has been filed as recently as this morning, or actually it's not been filed, it's been issued. We've given notice to Diligence that we believe that the devices planted on the vehicles of Mr. Pugachev's automobiles, those of his wife and children that they frequently use, is simply unacceptable and unlawful and in violation of the 1987 Harassment Act of the United Kingdom. That proceeding will not formally commence until we serve that proceeding, which will occur sometime in the next 2 weeks. They have been given notice of the claim, however, which is relevant, yet apparently Mr. Pugachev is still followed even here in France, which is disconcerting. I'd like to turn it now to the International Investment Treaty claim, which I would preface by saying Mr. Kehoe is a modest man, but Mr. Kehoe has been involved in notably some of the most relevant litigations in recent history. The firm King & Spalding, you'll see later on, is a very well-known firm that represents, normally I can't think of a case you represented the state recently, of recent times. Ed wakes up in the morning and he loves to figure out how to get those abused by governments unlawfully some type of return for their investment. So Ed, if you could please guide us through the ever-exciting procedural matters, and as well as a brief overview of exactly what occurred, it would be appreciated. Thank you.
Sure, I think I've broken the microphone in the interim. Oh, it's working? So I'm Ed Kehoe with King & Spalding. Today, Mr. Pugachev commenced an international arbitration case against the Russian Federation. An international arbitration case against a state, you probably aren't, or maybe you are familiar with it, but it's based on a bilateral investment treaty. There are over 1,000 of them across the world between countries. There happens to be one between Russia and France. And a bilateral investment treaty is a document, an agreement between those two countries that if a citizen of one of the countries invests in the other country, that citizen will be protected from unfair and inequitable treatment, from expropriation, from being abused. And if the citizen feels that they are being abused, that the state is violating the treaty, the citizen has a direct course of action against the state in international arbitration, because normally states are immune from being sued, but under the treaty, the states give up that immunity and they allow themselves to be sued directly in the international court under the treaty. And that is what Mr. Pugachev has done. Many others have done it before him, not only with respect to Russia, but with respect to other countries. This is just an area of the law that allows an individual or a corporation to sue a state. As I mentioned, the applicable treaty here is the Russian-French bilateral investment treaty. We have designated The Hague as the seat of the arbitration. The Hague has been the seat of many significant arbitrations, including the Yukos case against Russia that was mentioned by my friend Ms. Faustier earlier. We have not appointed an arbitrator. We will. We will appoint one. Mr. Pugachev will appoint one, I mean. The Russian state, if it participates, will appoint one. And then those two together, or the Permanent Court of Arbitration will appoint the chair. Those three people will decide the outcome of the allegations that Mr. Pugachev has made in his filing today. I won't detail all of those allegations. We've heard about them already. You've seen the substantial investments that Mr. Pugachev had, and which, as Mr. McNutt pointed out, were taken away from him without compensation very quickly. The damages that Mr. Pugachev is claiming in the arbitration are in excess of $10 billion. And the main thrust of his claims are that these assets have been expropriated without compensation, that the government of Russia has treated him and his investments unfairly and inequitably. Those are terms of art in the international arbitration world. And that Mr. Pugachev should be compensated for all of the harm that has befallen him at the hands of the Russian state. That's pretty much it. I think everyone else has given the details. That's the nub of the international arbitration case.
Thank you, Ed. I'll close before questions with a general observation. Various relevant political and otherwise strong, substantial business persons in Russia have been implicated and are involved in each of these different investments. For example, former Deputy Prime Minister Igor Sechin, clearly with his United Shipbuilding Corporation, had an interest in obtaining the shipyards of Mr. Pugachev. And we allege, together with the assistance of the head of the central bank, Mr. Ignatiev, he colluded to work to deprive Mr. Pugachev of that shipbuilding asset. That shipbuilding asset is the asset that builds the warships, that builds the nuclear power stations, floating stations, that builds the icebreakers. Russia strategically, evidenced by President Obama's recent visit to Alaska concerning the Arctic Circle, needs and and needs to maintain its perceived dominance in the Arctic Circle. Each of these investments represents a strategic company inside the Russian Federation. These are not random investments for football clubs or other types of investments. These are relevant investments weaving together the social fabric. And as a consequence of these actions by the Russian Federation, they not only affect Mr. Pugachev, but as Ms. Forestier pointed out, they destabilize the local communities, they destabilize certain financial issues, and frankly are unacceptable in any reading of the obligations of Russia under the International Investment Treaty between Russia and France. With that, I'd like to open the floor to questions, please, and thank you all for your attendance.
Thank you very much. I have a question. If I understood Ms. Forestier correctly, Mr. Pugachev received French citizenship in 2009. I'm interested in what basis he gained French citizenship, and also, since his investments were thereby made before he was a French citizen, whether that would impact the arbitration proceedings. Thank you.
Leah, why don't you take the first question, and Ed, if you could take the second, please.
Sure. Donc, M. Pugachev a effectivement obtenu la nationalité en 2009. Son premier enfant, Alexandre, est français, de nationalité française, et par ailleurs, il a investi et s'est investi en France depuis de nombreuses années. Ses investissements s'élèvent à 200 millions d'euros. Et je n'ai pas les détails de son dossier puisque je ne m'en suis pas occupée. Simplement, il y avait déjà suffisamment de critères pour la demander. Et bien évidemment, il y a des décisions auxquelles je n'ai pas été associée et sur lesquelles je ne peux pas vous éclairer.
You raise a good question. These cases normally have what are called jurisdictional objections, where the state will argue that for one reason or another, the treaty doesn't apply. And one argument that is sometimes made is citizenship or nationality. Now, similarly, I am not going to get into our legal case too much here, but I will just, from a very basic treaty analysis, the most important question in citizenship is, was he a citizen when the assets were taken? Not when was the investment made. And he was a citizen in 2009, and the assets were taken after that period of time.
Thank you. Yes, please.
Thank you. This is a question for Mr. Kehoe. I'd just like to know, you mentioned there have been lots of cases before against the Russian Federation. Have any of them been successful?
Yes. One comes to mind, the Yukos versus Russian Federation case, where Yukos brought an international arbitration claim under a similar treaty. Similarly, the seat was The Hague, the Netherlands, and the tribunal was an esteemed international arbitration tribunal of the type that we will have, and they awarded Yukos $56 billion of an award against the Russian Federation. Right now, Russia is, the term is set aside, but what you would understand it to be is an appeal. They're trying to appeal it to the courts in the Netherlands. But we have some very good precedent in the courts of the Netherlands where another country attempted to appeal an award that was rendered by an arbitration tribunal in favor of a claimant. I was involved in that case. It went all the way up to the Supreme Court of The Hague, and they refused to touch or set aside the arbitration award. So there is a final arbitration award. There is not yet against the Russian Federation for $56 billion. It just came down last year. We don't have a final decision from the Supreme Court of The Hague, but that's an answer.
I've got a list also that after the conference I can help with claims against Russia in particular. It's 2 pages of claims. So
Just if the claims are, if you have precedents, but has any money actually been extracted from the Russian Federation for UCOS or for any of the others?
It's a good question. With UCOS, I don't know. Once you have, I'm not representing the claimant in the UCOS case. That's Sherman and Sterling. They have every right to, I believe, unless there's something going on in the case that I'm not aware of, but they have the right to seek to collect on the judgment by freezing assets if Russia doesn't pay. I do know that Russia has not voluntarily paid just based on the press reports, assuming the press is right in what they say, which I'm sure they are. So to my knowledge, Russia has not voluntarily paid. Now, normally, states do ultimately pay international arbitration awards. And the reason is, part of these treaties are designed to encourage investment in countries. And it's one thing to get in a fight with a claimant and you take your position and they take their position. That's fine. But if you lose, if an international tribunal declares that the state loses and that is not set aside by a court, most often in this international system, the state pays, because if they don't, then international investment into that country dries up because there's no confidence that the state is acting as a trustworthy international citizen where where it follows the rules. Now, Russia doesn't have an obligation to pay right now if it's in the set-aside process of the UCOS award, and I just mean that colloquially. Until that court speaks, they will say the jury is still out.
Guy Falconbridge, Reuters. It's probably a stupid question, but how long will it take, do you think, before you get some sort of decision? Because lawyers can work slightly more slowly than some other professions. And I had another stupid question, probably just when did Pugachev actually leave the United Kingdom? Because I think there was a court order in the United Kingdom preventing him, or his passport had been retained. Could you give any clarity on that? Thank you.
Thank you. Why don't you go first? Oh, do the passport first, I think.
Well, precisely when he left, I don't actually know, but I believe it may have been sometime around the end of June.
And the judge said that it was, I think one judge called his behaviour deplorable.
Well, I don't recall exactly what the judge said, but you've got to remember that the reason why Mr. Pugachev left was because he was in fear, very real fear, for his life. It's not very pleasant finding black boxes underneath your car in circumstances that Mr. Pugachev finds himself in a very serious fight with the Russian state.
And these questions are anything but stupid, I have to say, in fairness. You guys are on top of it. These cases do take a while. Normally, as you point out, litigation takes a while, but these treaty cases take even longer. And we can expect, if history is a guide for a case of this type, it will be at least 2 to 3 years before we would expect a final award. It's unfortunate, but it is a reality of this system.
Catherine Belton, Financial Times. Can I ask 2 questions? One to Mr. McNutt about, you said that after the investments were taken, there was some kind of impact on the communities. What do you mean? Has Russia's ability to produce ships been impacted? Has Russia's ability to produce coal been impacted? What do you mean? And then the second question to Mr. Cherryman, I wanted to ask, how will the filing of this claim impact the freezing order case, given that this claim far dwarfs anything that Russia is claiming against Mr. Pugachev? And how is it that Russia is filing this freezing order case against Russia, against Mr. Pugachev anyway, if it took away his entire business empire?
That's a great question. Again, Mr. Keogh can speak to this probably far better than I can, but what Mr. Pugachev is experiencing in London is a symptom, is a consequence of the inequitable and unfair and unlawful treatment that he has suffered at the hands of the Russian Federation. If and when necessary, we will be relying upon the BIT claim in London with a view to stopping what is going on in London. And indeed, if the claimants in London do seek to enforce any judgment against Mr. Pugachev's assets in London, we will similarly rely upon the BIT claim, the allegations that are being made in relation to what's occurred to Mr. Pugachev, to stop any enforcement against Mr. Pugachev.
Concerning your second question, I'll give a brief answer. I think practically speaking, given what's occurred in the Ukraine recently, the sanctions are probably not assisting in the development of those projects. Quite relevantly, however, and notable, is that recently the Russian government has announced the same financial support, basically, for the railroad to be constructed in the Tuva region of the coal mine system, EPC, that Mr. Pugachev owned. They've announced that together with the new owner, who is magically Mr. Altushkin and Mr. Bayzarov, the friends of Mr. Kaidirev. And the Chinese state has welcomed that investment and will support that investment, which is publicly disclosed. So effectively, everything Mr. Pugachev intended to happen with his guide is happening. The shipyards are a little more complicated just because what occurred at the shipyards, as evidenced by Mistral. And that's why I say the shipyards are more complicated, because of the military dimension of those shipyards. Sir, you had a question.
Hi, Stephen Gray, also from Reuters. I was just reading on the way over here some of the judgments from the UK. And perhaps I could just put to you one of the points made by a judge there. He made the point that he said that in December 2001, Mr. Pugachev became a senator in the Russian parliament. I believe he remained so until 2011. And he says, as such, he was barred from engaging in business activities or participating in the management of legal entities. Now, so how can you say that he indeed owned or acquired this $12 billion of assets, given that, according to this judgment at least, he was barred from participation in business activities? And to what extent does his status as a Russian senator allow him to take up his rights under this treaty, Russia-France treaty?
I'm just going to make one quick question and let Ed fire in. You're talking about an English judge interpreting Russian law on the rights of a senator to own businesses in Russia. And I think you'll see from the claim that Ed will explain, the Russian legislation actually did not prohibit what occurred, and the English judge is slightly mistaken in his understanding. But that mistake might be reasonable, given the fact he's been presented with limited evidence.
The other part of your question ties back to the citizenship and the question that was asked earlier. And again, these are all going to play out in the arbitration. Part of the reason these cases last so long is that the states usually mount some type of jurisdictional objection of the type that you're alluding to, and we fully expect Russia to do it in this case. The reality is that he has dual citizenship. Under some rules, the ICSID rules, dual citizenship could preclude a claimant from suing under a treaty by virtue of the fact that he or she or it has dual citizenship. That rule does not appear in the UNCITRAL rules, the United Nations rules that was up on the slide earlier. And we believe, and again, I don't want to get into the legal case too much, but there is authority, good authority, for the fact that under the UNCITRAL rules, dual citizenship is not a bar to bring in a claim under the treaty.
Just, 1 second, please. There's a question from the Russian media that my associate will translate for us. Thank you.
Hi, everyone. If Sergei Pugachev is planning to come back to the UK, and if yes, then when? If he's planning to come back to the UK, then how is he going to explain to the English court that he breached the English court's ruling not to leave Britain? And the fact that he didn't give the French passport. If he still has a French passport at the moment, and if he holds any other passports.
Nick, you want me to do that? Complicated question, so we're going to try to make it simple. One, Mr. Pugachev, with the pending extradition request, until that extradition request is no longer a threat to Mr. Pugachev, he frankly should not return to the UK. He is very distressed about that because his children, his partner of over 10 years is together there. His life was established there, so he's not happy about that decision. Explaining to the UK courts, frankly, has already been done. We've explained to the UK courts that the decision to leave the UK was a consequence of his fear for his life and his safety. In open court, Hogan Lovells, the attorneys for the Russian state in those proceedings, have confirmed that diligence was in fact putting devices on Mr. Pugachev's automobiles. That's not even dispute. They admitted that after the fact, after Mr. Pugachev left, and yet they say, we find it unreasonable Mr. Pugachev would be afraid for his life and safety because we're in fact the ones who put the devices. Somewhat disingenuous from our perspective. He does still hold his French citizenship? To the best of my knowledge, he holds no other citizenship. Oh, Russian citizenship, of course. That's evident. Yeah, great. Should we take one more question and then close it and we'll go to coffee? Does anyone have one more question? Excellent. We do have one more question. 1 second, please, or two.
Do you have any idea who was following Mr. Pugachev in France? Do you believe it to be diligence as well, or some other? Do you have any ideas?
It is a matter for speculation, obviously, because we have no evidence, in fact, it is diligence. We would say that yesterday an application was made in the UK proceedings, which we have yet to review. That application may, in fact, shed some light on who, in fact, would be following Mr. Pugachev. The involvement in this claim against the Russian Federation strikes at the heart of the current Russian regime. You know, President Putin is directly named in these proceedings. Medvedev is named in these proceedings. Sechin is named in these proceedings. All of the people that you would expect a person of Mr. Pugachev to be involved with at the level of business he was involved with, as effectively a power broker and an international business person in the Russian Federation since the early 90s, he probably doesn't have only friends, particularly friends that he names in arbitration claims for over $10 billion.
And just a clarification, when Michael says these people are named, they're not named as parties. The treaty only covers the Russian state. They're just, what he's saying is in the arbitration request, the factual background, they are named in that.
Thank you for that. Obviously, this isn't a criminal court, it's an arbitration court, and we're simply saying that the parties who hold the levers of power to establish the conduct are some of the names that I mentioned. Thank you. Okay, thank you all for your attendance. Please, we'll be mingling outside for a few moments. Please feel free to ask us your questions. And thank you again for your attendance today.